You know that on this program, and actually the stuff about the Disinformation Project and others, we are often well ahead of the curve when it comes to social commentary about changes in our nation, particularly changes not mandated through a democratic process, I think it would be fair to say. And we were talking about the Disinformation Project long before it was fashionable. And we went very, very hard on the story about Unijagos, the Solicitor General, who appeared to be setting quite racist policies in regards to prosecution under the Crown law system. And publicity around that story has seen her withdraw those absolutely crazy ideas. We were therefore very interested, and as we are in most research they put out, a new paper released by the New Zealand Initiative entitled Who Makes the Law? And a very interesting analysis of how our judiciary, our judges, particularly at the highest level, have engaged in practices which see them not enforcing or applying the law as passed by our democratically elected parliament, but in interpreting it in their own, often very liberal way, often in a way at odds or contrary to the intent of our democratically elected lawmakers in Parliament. The author of that report, Who Makes the Law, is head of the initiative, Roger Partridge, and he joins us on the line now. Roger, thank you very much indeed for taking the time to talk to us.
Good morning.
It's a big paper and it's worthy of reading in total. But have I got the broad thrust of what you're saying right? And that is there is something disturbing or something we need to examine about the actions of our judges, our top judges, in the way they're applying the laws passed by our Parliament.
Yes, we're seeing a Supreme Court in particular, but courts generally, that are increasingly overreaching. And they're stepping into Parliament's role. It's helpful to think about the respective roles of Parliament and the courts, I think, in this way, that the court's principal role is backwards looking. It's to interpret and apply the law to disputes between particular litigants that come before the court. And Parliament's role generally is forwards looking, to set the rules of the game, if you like, to make the laws that will apply to the future. And what we're seeing increasingly is the courts stepping into Parliament's role and becoming lawmakers. And there's a good cautionary tale about the dangers of that, because, look, perhaps we'll come to this, but it's highlighted very succinctly by Professor Richard Eakins, Oxford's constitutional law professor, who wrote the foreword to the report.
And what does he say, Roger?
He refers to the cautionary tale we see with the United States Supreme Court and what happens when judges become lawmakers and make the big social policy decisions which we'd expect to be made by elected parliamentarians. They effectively politicise the judicial role, and it leads to less certain and predictable laws. It leads to less trust in the impartiality of the judiciary and an erosion of the democratic legitimacy in the US of the legal system.
Roger, actually, I think there's an interesting parallel here with our mainstream news media, which has lost huge amounts of public trust, in fact, more than anywhere else in the Western world, because of its embracing of advocacy journalism and its abandonment of the principles of impartiality. Would you see that similar trend in the judiciary?
I think you can see a similar trend. And one of the beauties of our legal system, more or less to date, but less and less so over the last decade or so, is that ordinary people don't know the names of any of our judges, because the judges are just dispensing decisions in an impartial way. Ordinary New Zealanders are more likely to know the names of US Supreme Court judges than they are of our own Supreme Court judges. And I think that's something that's at risk as we see an increasing overreaching Supreme Court. Yet our court seems blind to the risks of taking us down the same dangerous path as we see in the US. And it would be a great shame if we ended up with a judiciary that are known because of their political views, as we see in the United States, of whichever shade, whether it's conservative or progressive, to use the terms used in America.
Yeah. Roger, it's interesting. I was going to ask you for an example, but in fact we did an interview on a perfect example of this yesterday with Stephen Franks, and that was the court's interpretation of the original three strikes legislation.
That's right.
Which essentially completely stymied it.
Yes, that's right. Fitzgerald's a good example of one of two areas where the report analyses where judges are stepping out of their lane, if you like. The first is in interpreting Parliament's words, statutes, legislation as we know it, where Parliament is increasingly where the courts are increasingly giving themselves a very broad licence to stretch or sometimes even ignore Parliament's words. And that was the case with Fitzgerald. And it's highlighted by an extremely strong dissenting judge from Justice William Young, where he says the majority's approach was not interpretation, it was rewriting the law.
Yeah.
So that's the first area. The second area is in relation to the common law, which is judge-made law, which they laid down over centuries, setting out principles that are applied in ordinary, everyday disputes between New Zealanders. And the common laws like what promises can be enforced as contracts, often they've been enacted by statute, so codified, but there's a big body of legal principles which we inherit from decided cases over many centuries. And the judge's role there is to apply the principles. Sometimes they need to fill gaps. Sometimes they'll work out that one principle is inconsistent with another and they need to amend the common law principles. But our courts see their role as taking the common law on a journey to match their views of society's changing values. So that's a second problem, where they're basically seeing themselves as social engineers. There are three big problems with that. Firstly, judges aren't equipped to make those sorts of assessments. How do they divine what society's changing values are without the submission-making process, for example, of Parliament? Secondly, disputes come before courts in particular ways with particular facts and particular legal counsel. So it's very hard for judges to think broadly about how a big change to the ramifications of a big change to the law, because they're looking at an issue through a particular lens, looking at the facts between the parties. And third, the big social policy changes made through the courts don't have the democratic accountability. Judges aren't politically accountable like parliamentarians. If
and in some cases they are implemented or they take effect and change our nation without the citizenry being even aware of what has happened, Roger.
Until after the event, that's right. And that's the problem with judges making law, the last problem, that they're not democratically accountable.
Yeah.
And that's the beauty of our parliamentary democracy. If we don't like what our parliamentarians have done, we can boot them out.
And we can't really do it with judges.